My name is Maddie Lister and I'm an associate based in Edwards Law's Auckland office. During this vlog, I'm going to discuss the pitfalls that many employers fall into when it comes to casual employment. The term casual employee is not actually defined in employment legislation, but most of us know it as a situation where an employee works on an as and when required basis. The most distinguishing features of casual employment are that there are no fixed hours of work each week, and an employee receives pay-as-you-go holiday pay, equating to 8% of wages. This is instead of providing an entitlement to 4 weeks annual holidays. Sometimes it can be difficult to determine whether an employee is truly a casual, particularly if they've been employed for some time. In these tricky situations, it can be helpful to consider the following list of factors which have been assessed by the employment institutions to be consistent with casual employment. 1. There is engagement for short periods of time for specific purposes, i.e. Christmas holiday casuals. 2. The employment relationship lacks a regular work pattern. 3. The employee's employment is dependent on the availability of work demands. 4. There is no guarantee of work from 1 week to the next. 5. There is no obligation on the employee to accept another engagement, so the employee can turn down work on offer. This is something that employers often forget, particularly around busy holiday periods where certain shifts may be less popular than others. And 6. Employees are only engaged for the specific term of each period of employment. It is recognised that despite being initially employed on a casual basis, the nature of employment can become more permanent over time, where hours of work are no longer intermittent and irregular. Accordingly, it is where the pattern of work becomes sufficiently regular and continuous, i.e. the employee is working the same days or hours each week, where the employee has a reasonable expectation of ongoing work, and where the employee is required to show up each week, that the casual relationship could become permanent. If a casual employee's employment has ended suddenly, should the employee successfully argue that they were actually performing the role of a permanent employee, this could give rise to an unjustified dismissal grievance. Furthermore, if a regular pattern of work has developed, but the employer continues to pay 8% holiday pay for 12 months or more, the employee will become entitled to paid annual holidays, and any amount already paid on a pay-as-you-go basis can't be deducted. So, how can employers avoid the traps associated with employing casual staff? First, employment agreements should clearly set expectations of both parties to a casual employment relationship. Employers are also encouraged to continually monitor their casual employees to check their work patterns, identifying whether they continue to be offered and accept work with the right to decline work, or whether they are now working regular days or hours or being regularly incorporated into a roster. If you think an employee is creeping away from being casual, either nip that employment relationship in the bud or consider whether it is time to offer them a fixed term or permanent employment agreement. And finally, if in doubt, the conservative approach when terminating a casual employee who may not truly be casual is to undertake a formal, although truncated process. This could be in the case of a disciplinary matter or where the need to restructure arises.